It's my pleasure to welcome you all to Thornton Bharat's webinar on challenges and learnings on the Faceless Assessment Scheme. Before we start, a few administrative points. Please use the chat box to type your questions to the panel as we go along during the session. Time permitting, we will try to address the questions during the session. Of course, given the nature of the issues, we may not have answers, but we may have questions only to address to a larger gathering. If you are unable to address your questions during the session, we will respond over email. On 13th of August 2020, the Prime Minister rolled out a new platform comprising of the scheme of faceless assessment and the taxpayers charter. This has been followed in September 2020 with the faceless appeal scheme and further with the introduction of the faceless penalty scheme and the proposal to move towards a faceless income tax appellate tribunal in the budget of 2021. The faceless assessment scheme is one of the significant cogs highlighting the efforts of this government to simplify compliance around income tax matters. There is this old saying that cliche actually, that there is an opportunity in every difficulty, and this aptly summarizes the timing of the government's move to use the pandemic times to push for adoption of these schemes. Undoubtedly, the move is equally, if not more, an internal department-facing step towards providing a platform to the taxpayer that promotes transparent taxation and honors the honest taxpayers. The major incentive of going faceless was to impart greater efficiency, transparency, and accountability by eliminating the interface between the tax officer and the taxpayer to the extent technologically feasible. CBDT has, in this line, notified the National Faceless Assessment Center at Delhi and the various regional faceless assessment centers across 20 cities of the country for implementation of the scheme. The key features of the scheme have been the introduction of a team-based assessment, a system of internal reviews, dynamic jurisdiction, and technical specialization. Further, the system has been fine-tuned to put in place selection of cases through a data analytics and use of artificial intelligence. To discuss specifically on the contours of the scheme, the National Faceless Assessment Center is the single point contact with the taxpayer. It issues notices to the taxpayer specifying the issues for selection of cases. Any information, documents that are required from the taxpayer or any other person at any stage of the proceedings, communications happen through the National Faceless Assessment Center. This central unit assigns the cases to specific assessment units in the regional faceless assessment center through an automated allocation system. The regional center facilitates the conduct of e-assessment proceedings through assessment units, technical units, verification units, and review units, which are the back end of what you see in the front end being the National Faceless Assessment Center. We are nearing 1 year of introduction of the faceless assessment scheme, and it is the right time for us to do a fact check and look at the ground realities to see what has been the impact of the faceless assessment regime. We are faced by challenges, certainly, and what are these challenges that we are facing, and what are the learnings coming from the implementation of the scheme for so long, are what we will focus on in this panel. With this, I have the pleasure of introducing the panelists formally to you. I'm joined by an esteemed set of panelists. We have Senior Advocate Ajay Vohra with us today. Mr. Vohra is a qualified chartered accountant and lawyer and has been practicing for the last 36 years in the areas of domestic and international tax. He's a leading arguing counsel before tax tribunals, high courts, and the Supreme Court. He has argued several cases involving complex issues having wide ramifications, which have contributed immensely to the tax jurisprudence of the country. Mr. Vohra has been rated as one of the most highly acclaimed legal experts in the Asia Pacific region in the field of taxation by Asia Law Leading Lawyers Guide for each of the years from 2006 to 2014. The Legal 500 have also introduced him into the Law Hall of Fame for Asia Pacific for having been recommended as the leading individual within tax for 13 consecutive years. Welcome, Mr. Vohra. Next, I'm joined by Mr. Balasubramanian K with us on the panel, who is the Vice President and Global Head Tax at Wipro Limited. He has over 20 years of experience in industry with regard to corporate tax compliance across tax jurisdictions, including India, US, Europe, and Asia Pacific. He is well versed on matters ranging from corporate cross-border M&A, business reorganizations, EU VAT, and social security. He is the co-chairman of Direct Taxation Committee, Bangalore Chamber of Commerce and Industry, a member of the Taxation Committee of CII, and a member of the core team of NASSCOM for taxation issues, including GST and emerging global tax developments. Welcome, Bala. We are all joined by Mr. Rahul Verma as well. He is a Senior Director, Tax of Cipla Limited. He comes with over 20 years of experience in the field of taxation. He carries experience in leading many corporate initiatives, restructuring and transitioning projects. He has served on committees on finance, taxation, and regulatory matters for various industry forums. Welcome, Rahul. Finally, I'm joined by Mr. Riaz Thingna, who is a tax expert and has over 35 years of experience in tax and regulatory matters. Welcome, Riaz. Let me now hand over to Riaz to initiate the panel discussions. Over to you, Riaz.
Thank you, Sridhar. So before I begin, Sridhar has graciously introduced everyone, but could not introduce himself, so I'll do that. Sridhar is a qualified company secretary and a lawyer by profession, and has more than 24 years post-qualification experience in tax and regulatory matters. He's a tax partner with Grant Thornton, Bharat LLP, and is based out of Chennai. So as Sridhar has rightly pointed out, India is indeed a pioneer in introducing the faceless regime for tax assessments. Some other countries like UK, US, Australia, Brazil also have faceless assessments, but not with the total coverage that we have in India. So in my view, this scheme could not have been introduced at a more opportune time, with the pandemic driving us all into the safety of our homes. I think just the sheer fact, the relief of not being required to attend tax offices, that by itself is enormous. But more importantly, it can potentially bring about a lot more transparency in the system and minimize subjectivity and bias. Now, is this really happening as intended? We'll find out from our panelists today. Here, I would just like to highlight a few statistics. Since the scheme was introduced, more than 80,000 cases have been completed under the faceless assessment scheme. Even more interestingly, 94% of these cases did not involve any addition at all. The submissions made by the assessees were accepted with no additional tax or penalty. However, like with all major changes, this scheme also comes with its own share of challenges and glitches. On one hand, there are procedural issues like data handling or technical glitches. And on the other hand, there are more behavior related issues, like too much data being sought by the tax authorities, sometimes irrelevant or at least unnecessary. Also, not enough time being given to the assessees to respond. And as a consequence of all this, there have been a lot of approaches in terms of litigation before various high courts, like writ petitions that have been filed in the recent past. Now, with an esteemed panel that we have today, let me straight away jump into picking their brains on the various aspects of the issues that have been raised. Let me start with you, Bala. The Faceless assessment scheme was launched with the objective of providing the taxpayers a transparent, painless, seamless experience. Based on your experience so far, do you believe that it has been able to meet these objectives?
Yep. Thanks, Riaz, and thanks to Grant Thornton for having me here to discuss about this Faceless. To your question, Riaz, I think it is too early to pass a verdict on this, right? Because it's just been 1 year. We've all been through a pandemic time where all of us, at least most of us who have been in the services industry, have worked from home, and our offices have not opened, right? And even if you look at the court hearings, they've all been through the electronic mode. Many of the courts have opened the electronic hearing, so we have all got used to a kind of an online so to say proceedings, right? And therefore it was a very opportune time for the government to introduce this. And in fact, if you look at it, they advanced the timeline. It was supposed to come in only some part of this year, but they advanced it and they got it last year. So given that, and given the long-term objective in mind, because this is going to be a cultural shift in the tax administration, right? What is a Bapu mindset is going to change to a taxpayer-friendly, taxpayer delight kind of an organization. So I'm not being sarcastic here. I'm not being. So this is the objective with which this has been introduced. So therefore, we have to give with any system. You have to give time, and therefore you will have to look at how it unfolds. And I'm sure the government is also going to learn from this. It's not that the government is going to close their eyes after having introduced it. They're going to learn from each of the glitches and each of the concerns that each one of us will flag, and endeavor to correct it, right? And we'll talk during the hour's discussion today, the various glitches and the various things that may rise, and also the legal points, right? Ajay sir is with us. He will put a legal perspective to it and how the courts will look at it, because even the courts mindset have to change, because some of them are new to the courts, right? Like the principle of natural justice, will the principle itself evolve? I think we need to look at the legal minds of Ajay sir, and look at whether there is an answer and whether there's an evolution which is going to happen over a period of time. But if you ask me whether the experience so far has been good, I would say it's mixed, right? As you rightly pointed out, more than 94% of the cases, they have not been any adjustment. So that's good news. But wherever they have resulted in some kind of an addition, I don't think it's a very pleasant process for some of us, and that's where we had to knock at the doors of the court, and therefore we'll have to see how this will evolve over a period of time, Riaz.
Thank you, Bala. I think that is extremely pertinent, the point that you made, that it's too early to pass a verdict. But yes, while it may be going in one direction or the other, we have to see how it really pans out. Yes. Rahul, at the practical level, coming to you, do you see any noticeable change in the approach of the tax officers? Do you see a difference in the manner they are now seeking information? Are initial notices now more specific to the case, or they continue to be generic fishing expeditions?
Yeah, thanks, Riaz, for giving that opportunity, and thank you. So, Riaz, in terms of, our experience goes with the faceless thing, and, the news of, faceless being introduced is a very, pleasant change to the entire regime. It's a welcome change, so to say, because, nobody would like to, sit, in the tax office waiting for the AO and waiting for his turn and explain something to him. And this is an opportunity wherein, we could explain the maximum by way of our written explanation, and the present opportunity, and probably it has been in line with making the tax system a non-adversarial, which has been kind of a tagline of Modi government when they came up with their first budget. But having said that, while the regime has been kind of implemented in a rush, as Bala said, while it has been planned for this year, but it has been already implemented last year. So that way, what we see is, most of these people, who had been doing the groundwork, they had not been properly trained, probably, on the entire mechanics of how to proceed with the notices and how to, do a risk-based, assessment, or a risk-based, notice or inquiry need to be made. So, as you rightly pointed out, I think most of these notices which just came, they are like a phishing inquiry, like, for a simple case of, charitable trust with small transaction, there are, notices coming in with, same questionnaire which would have been for a manufacturing company. And similarly for a, R&D lab company, one of our subsidiaries, a notice is coming, which is, very exhaustive and asking information which may not exist in the balance sheet itself. So that all has been the fact. But having said so, that could all be said, the first experience of the department and for the assessing. But overall, the way we see the whole thing progressed, there had been, questions which are coming very pertinent in the second and third round. And after that, there has been, discussion around the traditional way in terms of what has been your adjustment in the past and how to deal with those matters. And to our surprise, some of those past matters also kind of missed out in the final assessment order. So, which is, I believe, whether it's omission or whether they had deliberated and effectively given a relief, so to say. But on the similar matter, like, another company where the matter was not there, there has been addition. So the thing is, all sort of thing is happening. And we were wondering, whether this, the technical unit which is supporting the whole e-assessment regime or faceless assessment regime would actually supporting these guys in terms of giving technical material to kind of support their case and argument and making an addition. So even there we find that, somewhere that support is missing, in terms of, a routine adjustment like a 14A. So, there's no research work, no research precedent which has been kind of, put on record, just a, shallow kind of adjustment which is made without much of a research. So that has been, our experience, but otherwise, so to say, a lot of time saving and a lot of productive time which has, come to the, availability of the team to kind of, do creative work.
Great. No, thank you for those insights, Rahul. Yes, we've also read about cases where they've asked a company to provide all the bank statements completely with, explanations against each entity. But I guess this is all a learning process which will settle down as the system matures over a period of time. Sridhar, coming to you, have you faced any constraints in terms of the number of documents or the quantum of data, regarding submissions? Because I believe that you can't have more than 10 attachments, and each attachment cannot be more than 10 MB. So I think, how do you see that?
Yes, Riaz. So I guess this is more like a technical glitch, I would say, and the limitation that you can't load more than 10 documents at a time with a size limit has created certain issues in our ability to freely represent matters. In fact, linked to this is the fact that some of these, the portal itself has had some teething issues in terms of taxpayers not able to submit replies on time, inadequate opportunities being given for video conferencing and the tendency to kind of miss some of these issues that you could deal with if this was done in a physical form has been kind of been nagging on the back end. Technically, yes, I would say some of the issues that we've seen coming through are unnecessary show cause notices issued with short time frames for compliances. So that's also created some issues for us. And voluminous data, when you have multiple show cause notices coming through for the same issues, request the same data again. So it is kind of multiplied the filings in that sense, and we seem to be saying the same thing again and again in different words. But I think the spoken word has always been better understood than the written word, and therefore we are finding this to be difficult to explain in writing, especially given the nature of India's language barriers as well. English is differently understood in the South as it is in the North. So we have had those issues as well. So I would say size has created issues, but I guess it's also a barrier for depending on written communication more than spoken.
Great. Thank you. Thank you for those insights, Sridhar. Now, Ajay, you've heard all the problems. So I think we'll come to you for the solutions. So, with coming to the legal challenges, which we have seen in the recent past, many writs which have been filed by taxpayers against faceless assessments. Now, what are the major reasons for assessees opting for this constitutional remedy? And how are courts viewing it? In spite of there being alternate remedies like appeals available to the court, what is the view of the courts in this? So you'd like your insights on this,
Ajay. Thank you, Riaz, for that opportunity. The assessees, as has been spoken by my previous panelists, there have been issues and there have been glitches in the system. But before I deal with the specific query that you put to me, I would say that these are initial days. There are teething troubles that are coming in due to technological glitches, due to lack of orientation. But on the positive side, what I have seen in a couple of orders that have been subject of challenge before the High Court, at least there is uniformity of view. Rahul alluded to disallowance under 14A. The ones that I saw, clearly there was a uniform pattern that was followed across different assessees. So I would think that there is a central pool of knowledge or a repository that is now being created in order to ensure that pan India, the department takes a particular stand or a particular approach on a particular issue. So I think that will be good to eliminate subjectivity in the system. So having said that, I think the transitions that have been happening have resulted in frequent changes. As Bala said, we've rushed into it. We've accelerated the timeline of moving to this new section 144B. Now, and the pandemic has resulted in the extension of time limits for framing of assessments. Till the last minute, the assessing officer does not know whether he has to pass an order by 31st March or it will get extended to 30th April. So he, in order to save limitation, has been rushing to pass orders on the last date. And subsequently, when he passes an order 2 years down the road, 2 days later, it comes to light that the assessment time limit has got extended. So it is for that reason that, the assessees have flocked to the courts, availing of the constitutional remedy of challenging these assessment orders in a writ petition. As you very rightly said, you have the appeal procedure available to you. But the question is whether the appellate remedy is an equally efficacious alternate remedy. Considering that you would have to pay 20% of the demand, considering that you would be subjected to, penalty proceedings, further that the appeal would be litigated across different forums. So weighing the pros and cons of approaching the court in a writ petition versus availing of the alternate remedy, many assessees have come forward to move the court in a writ petition to seek a quashing of the order and in the interim to seek a stay on the proceedings, which results in the demand being kept in abeyance, the penalty proceedings not being proceeded with, and so on. So the courts have essentially looked at a violation of principles of natural justice. Although the section does not specifically mandate an opportunity of hearing, the courts are seeking to read this the alteram partem principle into the statute. And if you recall, in the context of the special audit, even before there was a provision making it necessary or mandatory for a hearing to be granted, the Supreme Court has held that an opportunity of being heard needs to be provided. So here, the commissioner may, the section says the commissioner may accord an opportunity of virtual hearing. But I think the courts are wanting to treat this as a mandatory requirement, that an opportunity of hearing must be provided if the assessee seeks an opportunity of being heard personally through virtual hearing. And the Act also provides that the government will come out with a scheme, guidelines, parameters as to when the opportunity should be provided. But to my knowledge, till date, the guidelines are still missing. So the court did, in a couple of matters, put this question to the departmental counsel that please produce whatever guidelines, parameters there are to say that the commissioner may or may not deny, may or may not accept the request for an opportunity of hearing. So I think largely the cases that have come up are with respect to violation of principles of natural justice. As you mentioned in your opening remarks, very little time given to respond to the notices. The assessment order being passed in a tearing hurry. There have been cases where the assessment was picked up for limited scrutiny and the final assessment order traversed on issues beyond the scope of the limited scrutiny. So all those kind of examples of cases that have come up before the courts, where the courts have been pleased to stay the proceedings or set aside the assessment to be done de novo after providing adequate opportunity of being heard to the assessee to lead a evidence, furnish reply, and also provide an opportunity of being heard. So more on that as we go along. Yeah.
Thank you. But just as a follow-up question, you referred to the principle of natural justice, and Bala also briefly referred to it. So could you explain more the principle of natural justice as applicable to faceless assessments? Because could that be a situation that, by its very nature, when the whole discretionary power vests with the officer of granting personal hearing or not, whether that by itself makes the entire scheme vulnerable to not complying with the principle of natural justice?
See, as I think Sridhar also explained, much of the work happens in the background, of which the assessee is not aware. You receive notices, you furnish responses on the portal. The department within the system may send it to the review unit. They will appraise the response, and they will then internally communicate between the different units as to what needs to be done with respect to a particular assessment. Now, thereafter, the section provides for issue of a mandatory show cause notice along with the draft order. And actually, the word draft assessment order is a misnomer which is causing all the confusion. It's not really an order in that sense. So to show cause why the assessment should not be completed as per the draft order. Now, you submit your rebuttal, and I would also endorse the point of view that the spoken word is better than the written word. You tend to miss when you read versus what you hear. If it's a combination of both, I think that's the optimum solution, that the officer takes into account your written submissions, grants you an opportunity of being heard, hears your oral submissions, and thereafter passes the order. So there have been instances where either you've not been given time to furnish the response, or the response that you furnished has escaped the attention of the assessing officer, or an opportunity of being heard has not been granted. Now, in all these cases, when the assessee asks for a personal hearing, and the personal hearing is subject to discretion of the commissioner, which I would think that the courts will over time strike down, saying that when an assessee does ask for a personal hearing, that needs to be granted, and all that is necessary for a fair, transparent assessment. So I would think that the courts will water it down, and this opportunity of being heard is being granted only after you've come out with a mandatory show cause notice. There is so much groundwork that has already been done in the meanwhile of appraising your responses, coming out with what you think will be the shape that the assessment order would take. So I would think that the matters will, at the level of the court, reach a favorable conclusion that you need to read into the statute this principle of audi alteram partem. I would tend to take that view.
Thank you, Ajay. That's really insightful. Coming back to the problems on the ground, maybe I'll address this to both Bala and Rahul. We have noticed that the time, Ajay spoke about it, Sridhar spoke about it, that the time given to the assessee to respond to show cause notices is sometimes too short, impractically short. To be fair, the first initial notice, there's always a 10-15 day time given, and there is no challenge in the first notice. But in the subsequent ones, the show cause notice, there is a challenge. So what has been your experience on the ground on this matter?
Yeah, I agree with you, Riaz. The time is too short, especially when a show cause notice is issued, right? Because that's that's almost the last stage before you receive an assessment order. And the time limit is too short. It's generally 2 days, 3 days, maybe in some cases even an intervening holiday or a Saturday or Sunday. So none of those are kept in mind when the timelines are fixed. And sometimes the show cause notice does not even take into account the responses already given, right? If they take into account the response and then say that I disagree for XYZ reasons, because mind you, it's the spoken word versus the written word. For us, it is the same thing on the other side, right? Yeah. If they don't write, if they are speaking to us, probably we can understand their mind during a hearing. In this case, they are not also speaking, right? And they are going to write and give their views to us. And if they are not able to communicate as well, in their draft order, so to say, which is, in the form of a show cause notice, we will not be able to exercise, our, the remedy of a response, an effective response to that show cause notice. So therefore, we have to be, mindful that, of course, our writing skills have to improve, even the department's, writing skills, because, they are discharging a quasi-judicial function here. And generally we talk about a last word being spoken, right, by the Supreme Court some 15 years, after, etc. But in this case, the first word to be spoken is going to be after 6 years, right? Because Commissioner appeals is faceless. The tribunal is faceless. So the first word that you will speak on a matter here before any person is going to be before a high court authority, a bench, right? And therefore, all of these, letters, the responses, the show cause notice, everything have to be impeccable. And therefore, we have to learn on all of these things. And unless, we find, a scientific way of, addressing this communication issue, this is not going to be successful at all.
Oh, very, very strong and valid points that you've raised, Bala. Rahul, any inputs from your side?
Talk about this similar issue of the timeline. So the thing is, the timeline are important when you are actually given the time. So I had experiences where no time is given. You straight away got the orders without some of the submission that you have made have not even mentioned or taken into account while passing the order. So I think that they're blatantly illegal and blatantly kind of defying the process itself, which is formed of the faceless scheme, so to say. Sorry, you're saying something.
No, I just wanted to add on your input as a personal experience. How have you faced? Has there been enough time given, not given? What has been actually the status on?
Somewhere like the time piece whenever this assessment proceeding is going on. in terms of, while there are issues around data upload and all that, there are issues around, seeking adjournment and all that. So all those things has, some rule-based thing, while there's some practical aspect. So the team of mine which is working on the assessment, they could actually figure out how they could, put more and more of data in terms of making partial submissions. In fact, more than 10, they have made, kind of, 20, 30 submissions, so to say. And when it comes to adjournment, also had been taken, so to say, by way of partial adjustment, partial submissions. So accordingly, while we sought for adjournment, no formal acceptance to adjournment has come, but yeah, till the time the assessment, this tab is open for submission for partial assessment. So that has been used as an opportunity to kind of make the submission. So, and as far as, the urgency on the part of department, that is kind of unfathomable in terms of, what kind of urgency they have. Even after giving time on the final draft order, they had, not, even allowed that much of time which is given in the notice, in the show cause notice. They've issued order before that. So that is something which has, I heard in, many cases in my form of attorney.
Thank you. Thank you, Rahul. Just again, alternating, Ajay, while we spoke about all the writ petition, and how the court is viewing it, I just wanted a couple of practical issues also. So could you shed some light, on what kind of important aspects that taxpayers should keep in mind before choosing the writ process? And the second part, again, another practical part, is on the jurisdiction issue. That when you have the national, Faceless Assessment Center based in Delhi, does the jurisdiction lie with the Delhi High Court, or does it lie with the court of jurisdiction of the assessee?
So to take up your first point about what parameters should be taken into account by a taxpayer while weighing the option of availing the writ jurisdiction, I think the answer that comes uppermost in mind is an expeditious relief. You are seeking an interim relief of having a stay on the assessment, having a stay on the demand that'll be kept in abeyance, and you're putting in on the back burner the penalty proceedings. Otherwise, if you avail the appellate remedy, the department will go through the motions of passing the order, in course of time, passing the penalty order. Then you have to run around seeking a stay of demand before the administrative authorities. And ultimately, you may have to go back to the court in a writ petition seeking a stay of the demand if you are not intending to pay the 20% pending disposal of the first appeal. So I think the assessees look at this, quick justice pitted against the fact of going through the entire motions of the appeal remedy. So I think that is largely the consideration that the assessees take into account while deciding that they would be opting to assail the order in a writ petition before the court. Now, in question of the jurisdiction of the High Court, yes, the National Faceless Assessment Center is headquartered in Delhi. So the Delhi High Court has the necessary jurisdiction to, deal with the writ petition that is filed before the Delhi High Court challenging the order of assessment. The assessing officer holding territorial jurisdiction is also a necessary party, because ultimately the records will be transferred by the National Faceless Assessment Center to the assessing officer to, compute the demand, pass a penalty order, and so on. So therefore, to answer your question, the Delhi High Court, certainly yes. The High Court having jurisdiction over the assessing officer, territorial jurisdiction over the assessing officer, would also have the jurisdiction. And that's how you would see, you have judgments from the Bombay High Court, the Madras High Court, the Andhra Pradesh High Court, dealing with faceless assessments. So there was a challenge, that was mounted in Delhi, and there was an argument put forth by the Revenue Council saying that the Delhi High Court does not have jurisdiction to deal with this writ petition with respect of an assessee whose territorial jurisdiction was outside of the Delhi High Court. So the High Court has, kind of ruled in favor of the taxpayer. saying that National Faceless Assessment Center is the one passing the order. The assessing officer exercising territorial jurisdiction has therefore only to implement the order that is passed by the National Faceless Assessment Center. And therefore, you cannot oust the jurisdiction of the Delhi High Court where substantial cause of action actually arises. So the cause of action or part of the cause of action is in Delhi as also in the state where the assessing officer is located.
Okay. So in your view, the primary jurisdiction would lie with Delhi, Delhi High Court. Right.
Although I may just, for completeness, point out that there is a 5-judge bench decision of the Delhi High Court in the case of Sterling Agro, where they are dealing with the power of the Delhi High Court to entertain a writ petition against an order of a central appellate authority. Let us say, for instance, the CESTAT, or let us say any other appellate authority. There, the Delhi High Court said that it is not only a part of the cause of action that will determine the jurisdiction. It is not only the minuscule cause of action that will give jurisdiction to the Delhi High Court. You also need to look at the question of forum convenience. So where the substantial cause of action arises. Now, this may be different than in an assessment situation, and especially where the National Faceless Assessment Center passing the assessment order is headquartered in Delhi.
Right. So that's very interesting. I'm sure at the end of this, Ajay, number of participants are going to start knocking at your doors to find their solutions.
I would just, if you give me 2 minutes, I would just want to supplement to what Rahul said and Bala said on the practical experience. I've seen some orders which I challenged in the High Court successfully. You see there, as Bala said, you got 2 working days over a weekend. And surprisingly, I was surprised, all notices said your reply should come before 23:59 hours on so and so day. And to Rahul's point, I have also seen cases where before the 23:59 hours elapsed, you had an order on 14:11 hours on the same day. So the order was passed also on that day, with the court, very willingly struck down, saying that the time that was allowed was also not allowed to run out. And an assessment order was passed before that date. This is largely to do with the fact that we've been shifting the time limit for completion of assessment. And this has largely happened in the month of April. The order was passed on 24th April. 26th April, the board issued timeline saying the time limit from 30th April gets extended to 30th June. So the assessing officer was not aware that, the time will get extended. So to be fair to the revenue, these assessments that have been completed without granting adequate opportunity are on account of this communication gap within the system.
Right. So if I can, read your mind to that extent, you believe that this is genuinely a teething issue. As things stabilize and mature, we should not be seeing too many of such cases.
I would think so, yes.
Thank you, Ajay, for that. And, again, let me come back to you, Bala. What are your views on the technology platform which is being used? Have you faced any challenges there? We've heard of various technical glitches like a non-responsive portal. Also, lack of facility to file rectification applications, etc. So have you faced any of these situations? And if so, how have you dealt with it?
Yeah, so in fact, we have not. So what will happen is we would have received the notice on email, but the notice does not show up in the website for you to go and click a response, right? And if you don't do that, you can send it by, so, if you call, the helpline, they'll say send it by email, right? But if you send it by email, there's no audit trail. Like what Ajay sir pointed out, there's a timeline, right? 23:59, they pass the order by 14:11. If it's a system-based tracking methodology, there'll be an audit trail. And I don't know whether, there's also a method to see whether, the assessing officer, whoever drafts the assessment order in the National E-Assessment Center, does he open the response and read it? How long does he eyeball the response? Those are the things that a technology can provide, a mechanism, right? If he just mechanically opens, we have had instances, I can speak from, my company's perspective. There's a SOX process, right? So an email comes to me, at say 10:01, and I respond saying approved, right? 1002. The auditor picks it up and says, how did you apply your mind on that? Right? It's a very detailed email. How did you as an approver, because it's a maker checker principle. So those kind of principles. So when you call natural justice and juxtapose that with technology, you need to ask those questions. It cannot be just thrown away, in the dustbin and say, you have sent a response, I disregard it, I issue a notice. Right? Whether the response was even considered, because the order does not even have a reference to the response. Right? So those are the things that are going to come up, as we mature in this technology, to see, how an effective, system is going to be used. Because, when you say technology depends, the success of the technology depends on the users. Right? If we don't make the answer to every problem that we have is not technology. We can't blame it on technology. If the users are not disciplined, as taxpayers and the tax administration is not disciplined enough to exploit the technology where it should be, it should not be reduced to a mechanism of a post box and you take out the response. It should be effectively used for us to make justice to the system that is being put out here, Riaz. So that I think that's very critical. I may say the same thing in different manner, but I think that's what is going to turn out to be.
No, I think you're raising a much larger issue here, that it's not just a change, it's a dynamic change which requires every level to actually adapt to this whole thing, whether it is the tax officer, it is a taxpayer, the appellate authorities, and the courts. So the whole process of even the principle of natural justice that Ajay referred to, if it is adapted to technology, then it will be applied far more effectively, and not generally. I think it's.
And I'll tell you one more thing, Riaz, here. Sorry to interrupt you. Right? If you ask for a video conference, right, and the video conference is given to you, and you make your point there, you don't know whether the assessee can record it. Right? He can record it on a phone and produce it before the court tomorrow and say, while I was given a video conference, facility, it was just a 2-minute conversation and I was not even allowed to speak. Right? Whether that will be allowed as an evidence in the court, we'll have to see. But then that's the peril of a technology that both sides should know, because once it is online, anybody can record it and place it. Right? And therefore the department also will be skeptical when they give you electronic hearing, and probably that is the reason why there is some kind of discretion exercise at the commissioner level to give only in very extremely deserving cases. Right? So therefore, even when online opportunity is given, it should not be just a semblance of an opportunity. It should be an effective opportunity that is given to you, and that will be tested, because it's going to be recorded in some place.
Absolutely. No, thank you, Bala, for that very detailed, and I think these points are valid, and I think it's a part of the maturity of the whole process where a lot of this will be addressed over a period of time. Rahul, in your view, this lack of physical meetings, we spoke about communication earlier. Does this create a big challenge, especially when there are complex issues? And talking about the video conferencing that Bala referred to, do you think that video conferencing should be made a regular feature in faceless assessments, or and not only in special cases? Because of course, then I'll ask Ajay whether it will be accepted as evidence in court, as Bala question. Yes,
that's true.
Yes, Rahul.
So as a matter of pleasant surprise, in few of our cases, this video conferencing window is always open. So to say, you can click and start onto the video conferencing or request for the video conferencing. That means that assessing officer itself kind of taken the requisite approval from the commissioner or whosoever, and made sure that video conferencing facilities are available. So that was a pleasant so to say surprise. And when it comes to explaining the critical issues, so to say the return explanation and all that. So I think one thing we learned is, about the drafting skill. When you are dealing with the matter, you have to be very precise and write matter in a very smaller words. You can't be very voluminous in terms of putting your submission into length of millions of pages. So that where the whole drafting skills of the team has been put to task, and we got some good result in terms of explaining the long thing short, so to say, and that has been very helpful. But yeah, wherever there is critical issue in terms of accounting and reconciliations and all that, it is very difficult to kind of explain even by way of plain English language in terms of how the reconciliation is taking place, like explaining typically this tedious reconciliation on the provisions and all that. The detailed explanation are asked, and detailed question are kind of put across. Very cumbersome, and there are multiple questions to and fro on that front. And in one of those cases, in fact, the video conferencing was not available, so we have to do multiple round of questions, so to say. So yeah, so that way we are learning also in terms of this new way of working, in terms of putting the long thing short, and something which is understandable to a man of ordinary prudence. Not a highly technical knowledge based technical officer, so to say. So this is what give us some good result in terms of putting across to them, and they accepting our submission.
Thank you, Rahul. So Ajay, just your immediate response: would that recording of these video conferences be accepted as evidence in a court of law?
Riaz, if you see currently, almost all courts are conducting proceeding virtually, and the proceeding would be recorded. So I would take it that suppose in a virtual hearing, you move for a rectification of the order or a review of the order, saying that this was contended. I think it will be open to the court to go through the video recording to say whether or not such an averment was actually made. And these are all public hearings. So I frankly don't see a reason why we cannot rely on the video recording of the proceedings to determine what was stated by either side in the proceedings, especially in a court of law. And I think if I'll just take your permission to add to what Bala said, when you are filing written submissions, inherent in this is the confidence and the trust that the other side will meticulously go through your written submissions. So this experiment can become a success only if the other side also displays that kind of commitment to read your submissions word by word, letter by letter, and ultimately come to whatever conclusion. I'm not on the conclusion. So this process is extremely necessary. And I'll just as a slight aside, just take 2 more minutes. I was pleasantly surprised in a Supreme Court matter. After many hours of arguing, the judge actually threw the file at my face and said that, Mr. Vohra, sorry, you have no case. It was a departmental appeal, and he said you have no case. And I asked for permission to file written submissions. And you would be pleasantly surprised that the judge turned around his decision basing on the written submission that were filed. So clearly the judge had gone through every single word that was written. Now, if that is brought into the system, I don't think you need a personal hearing. The Supreme Court has said personal hearing, the opportunity of being heard does not necessarily mean personal hearing. So if this is scrupulously followed at the end of the department, and within this department in this faceless scheme, you have several layers, you have several checks and balances. If that is scrupulously adhered to, the quality of orders is bound to improve. So we will not have these issues repeated, time and again. So that, I think, is the critical piece. And again, there should be no blanket ban on an opportunity of being heard. The point Rahul made, accounting today is extremely difficult, complex. We have Ind AS, we have this standard, we have that standard. Good accountants can't understand. So to expect the tax department, who has no orientation of accounting, to really understand what is presented in the accounts, what is the position taken by filing a tax return, there'll be a huge variation between your balance sheet and the position you've taken in your return. Now, somebody needs to understand, an accounting expert needs to understand. So giving that opportunity to reconcile the differences, including the tedious point that he made, I don't see this is in any way going to detract or take away from this faceless regime. So you are limiting interaction to only points that are extremely necessary in order to bridge the communication gap. That's the point I would seek to.
Yeah, so that actually brings me back to my original point here when we spoke about, when I said there are behavioral issues. So over the years, also an assessing officer has been used to being spoon-fed. So you could give submissions, but he waited for the personal hearing for you to actually, make him go through the entire submissions, and he wouldn't really read it. So I think that also is a part of this maturity of the process, where he will start reading those submissions by himself and applying his mind in a more judicious manner. So I think
As in vacuum, it is very difficult to be reading a submission and appreciating it in vacuum.
correct.
If you have an interaction with the person who's made the submission, it makes it more meaningful. It puts it in context. You are still free to take whatever decision you want to take.
Right.
But at least it helps understanding.
Right. Thank you, Ajay, for that. But just briefly, before I come to a final question for you, Sridhar, would you have any experience on some of these issues that are being faced on the lack of physical interaction?
No, absolutely, Riaz. I think a lot of things to iron out in that sense, but there's so much technology now, like Bala alluded to, that you have the technology to read documents as well, and those documents can then be synopsized and read out to you through the laptop or through the computer itself. So there is ability for the artificial intelligence of the machine to actually read this for you as well and synopsize. So this is an opportunity certainly for the department to start moving in that direction as well, which of course it will, and for us to also start linking submissions in ways technology can allow, so that we don't repeat things which we may have already said. So that's certainly things that can matter to us. But from a ground perspective, I would kind of see Rahul's point on TDS not getting kind of represented, even though it appears in the 26 years is a significant gap there. We've seen some deviations from the standard operating procedures where it is convenient to the department, where it's inconvenient to the SSC. And I guess from a technology point of view, the fact that we don't have the ability to understand if or see transparently if the department has actually seen the submissions, like a return read receipt of what has happened on the ground, because we don't have information whether the submission has been viewed and or read, and it's not tracked for us. It's the same thing for uploading notices in the portal as well, where we don't have visibility on when exactly is the notice, etc., uploaded by the NFAC. So that's a gap there. And obviously there have been issues on the portal itself not being allowed to look at. It's a design issue. It doesn't accept rectification of orders passed under scrutiny or stay of demand appeal. So that's a systemic issue. And we have seen some aberrations as well, where even non-resident taxpayers have also in some instances kind of got into this system. There is my understanding is non-residents do not get covered under the faceless assessments scope, and therefore there are some issues there as well. For smaller taxpayers, we are seeing this as a burden as well. So we are seeing technology being a barrier there for smaller SSCs and taxpayers, as well as for smaller firms in terms of their own practice. But it's maybe the hesitancy there, but technology should enable this to be more, make it more free, as I would say. I think that's broadly how I see it, Riaz.
Thanks, Sridhar. Ajay, one last question for you. What, in your experience, what has been the overall quality of orders? Have they been the internal checks made any difference, or are they well reasoned now, or high pitched? You've been coming across a lot of orders, and what is your general view on the kind of orders which are being done? And what would you advise for?
I have seen a broad spectrum of orders. I was arguing a matter where the multinational corporation was looking for a refund of the taxes paid, and that was processed under a 143(1). Now, an order was issued under Section 241A for withholding the refund, and the assessing officer, to justify the withholding, said the income should have been, instead of some 70 odd crores, it should have been some 220, 30 odd crores. Now, I was pleasantly surprised. We challenged that in a writ, and the court had given interim directions. But when the NFEC passed an order, they came very close to the return figure. So they had dropped all the adjustments that were made in the past, which I think Rahul also mentioned, that some adjustments that were made in the past were not repeated in this assessment. So I think there will be a conscious application of mind that those frivolous adjustments that were made in the earlier years need to be dropped. Again, as I mentioned to you, there is uniformity in orders. One would expect the quality of orders to go up substantially, except where there has been limitation of time. The assessing officer has rushed to make an assessment without going through your response. So I would leave that on the side and not say that the quality of orders has not gone up. But I would think that on the side of the department, there is a serious attempt to enhance the quality of orders, not make frivolous adjustments, not make arbitrary additions. All that will in course of time substantially come down. And my advice, and I'll go by what Rahul said, you see, as you move up the hierarchy, in the High Court, the court will limit your submissions to 3 pages. If the judge, gives you that latitude, it may go up to 5 pages. In the Supreme Court, it will be 2 pages. Now, in the 2 pages, you have to condense your facts, you have to condense the findings of the lower authorities, you have to condense your submissions, your reliance on case laws, counter what the other side is likely to state. So therefore, this requires substantial expertise, not only of marshalling the facts, but also the law. So I would think that don't load the assessing officer with verbose submissions. That doesn't help anybody. It must be articulate, crisp, to the point, supported by facts. And as Sridhar said, I would reference it to the papers that you are submitting as part of your compilation. Nobody today, you see, I think this is general human psychology. You can't read too many documents on the screen. There is generally an aversion to reading too many documents on the screen. My friend Bala is probably from an industry which is screen based and you will be used to it. I myself find an aversion to read documents. I would anytime prefer reading a physical document. But this limitation of the pandemic has forced me also to be working virtually. But having said that, so therefore we must keep ourselves to the limit, not have very exhaustive submissions which are all over the place. Be brief, to the point, and crisp, so that the point can be appreciated.
Thank you, Ajay. I think we've totally run out of time. Given all the sharp insights of the panel today, we could go on for another couple of hours, but unfortunately, we don't have that luxury of time. Thank you all very much, Ajay, Bala, Rahul, and Sridhar, for taking out time in your busy schedules. I personally have found this session extremely enriching, and I'm sure most of the participants will share my view. In terms of questions, I think we will get back to you with our responses on email. Thank you very much. Thank you for your participation.
Thank you. Thanks.
Thank you.
Thank you.